to the private note. Okay, let's go ahead and get started. John, the roll.
Present. Commissioner Eskovitz?
Present.
Commissioner Wasserman?
Present.
Commissioner Nguyen?
Here.
Chair Remke?
Yes. Okay, good morning, everyone. We're going to go ahead and get started. And before we do we have any public comment for any item that is not on the agenda today? Sir?
Thank you. Good morning, Commissioners. My name is George Barich. I'm a former city councilman in the city of Cotati, California. And I come to you today to state that for the last 16 years, I've been actively involved in my town's politics, running for city council and religiously attending all of my city council meetings and participating as an act of civic involvement, trying to carry the torch for common sense, reasoning, and so forth. And each and every election, I feel that I represent the independent conservatives in my town, and I run for city council. And if I had not run, there would be no race at all in the last 10 years. Last year, about this time, my city decided to put a sales tax measure on the ballot. I ran a small campaign against that tax measure, and the city put together some mailings that went out to the public. I believe in my heart, and the evidence will show, is political advocacy, clearly. There was also a political committee set up, which I believe grossly underreported their printing costs. The issue today for me is nearly 6 months ago, I filed 2 very clear and concise complaints on each of these items and provided the enforcement division all the evidence they needed. To date, I have not received a letter or any acknowledgement that I've even filed a complaint. I call every month since October asking what the status is. In years past, I usually will receive a letter from the commission saying they've taken my complaint under advisement and they're looking into it. And I understand these things take time. But 6 months and not having any acknowledgement clearly indicates that something is awry. I want to submit these 2 complaints to you. I have the evidence on file. Your enforcement division also has copies of my evidence. And what concerns me also, Commissioners, is that when I'm running for public office, the opposition will always seem to file frivolous FPPC complaints against me. They make political hay out of it. They go to the local newspaper and becomes headline news. And I'm defeated by 200 or 300 votes each and every time. Frivolous complaints that go nowhere. I run small campaigns. I self-finance my campaigns. And to date, I've never taken a dime from anybody for my campaigns, and I've never contributed a dime. And yet my opponents will file these complaints. And if I didn't know any better, I would say that your enforcement division here is shelving these complaints for political expediency. That's all I can think of. I would ask for your assistance here in seeing that these complaints are handled, and that and as a taxpayer and as an active citizen, that my complaint is taken seriously and my complaint is acknowledged. Thank you.
Thank you, sir. I will just add that all of our complaints are taken seriously, as will yours. You've left copies with our executive director there, and we will make sure that they're in the enforcement division and that they're being handled properly and that you will receive a response.
Thank you very much.
Okay, any other public comment? Okay, seeing none, we'll move to item 2, approval of the February 2015 committee meeting minutes. Are there any comments or corrections that need to be made? All right, seeing none, I'll move to approve the minutes. Is there a second?
I'll second.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, now we're going to go ahead and move to items 3 through 13, the proposed consent calendar on enforcement matters. Do the commissioners have any items they need to take off consent, not comment on, but take off? Okay, I don't see any.
I missed my cue.
Galena West, our acting enforcement officer. And before we get started, I just want to thank Galena for stepping into this role. She has been working very hard and getting up to speed very quickly. And in addition to all the enforcement matters, taking on other special projects as well and doing a great job for the commission. So thank you very much.
Thank you.
Are there any questions about any item on consent? It'll be an easy day for you.
I just had one question. I
Okay.
noticed that Gary is still on all of the stipulations. Or are we going to obviously adjust for
The
that?
ghost of Gary.
The coast of Gary.
Right. Actually, what we do is since these go out months in advance, they went under Gary's signature up until he left. We changed a week before he left. And so we cross out Gary Winnick and write in my name very professionally. And that's how that's taken care of.
That works.
Okay. Is there any public comment for the items on the consent calendar? Okay, seeing none, do we have a motion?
I move approval of the consent calendar.
I'll second.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Wynn,
Yes.
Chair Remke.
Yes.
This motion passes.
Great. Thank you, Galena. Okay, item 14 is the approval of the campaign manuals for local candidates and ballot measures.
Good morning, Commissioners. Linda Cassidy. Today I'm presenting two campaign manuals, the local candidate and the ballot measure manual. Both manuals have been out for public comment, and I'm incorporating some technical changes. The ballot measure manual in particular incorporates commission advice that we provided in the November election because there was a lot of new changes with SB 27. So I'm happy to have this ready because I've been reading there's already many state committees forming for 2016 ballot measures. So I ask for your approval.
Any questions?
Yeah, I just had one question. Linda, it said that the manuals were last updated in 2007, and I did see significant changes made
Yes.
reflecting. So, I mean, I just wonder what has happened in the interim as changes have been made to the law and to, regulations, and we've had manuals that have kind of been out
Outdated.
of date.
Yes.
Has that caused any problems, and are we going to do anything to try to, I mean, I know it's a hassle
Ongoing.
and a pain
Yes.
to, keep updating, but that's just a long period of time to have manuals.
I would totally agree. What happened, we had so many changes over the last couple of years, and during Chair Ravel's tenure, we started all the 800 series and so forth. So what we did was we had a series of fact sheets and updates that were attached.
Mhm.
But the way we've designed the manuals, so like, let's say, for instance, we have new legislation that changes this year,
Mhm.
then hopefully we can just take that one chapter that's affected, make the changes and bring it back to you that way. So that's the plan. So when we were redrafting them, we have shorter chapters trying to targets to make it easier. What I would like to do is just have the form and instructions and the manual pretty much
Mhm.
are the two main campaign advice pieces.
Well,
So
I did
that's the
think the
goal.
manuals were well done and they're easy to read and they seem really accessible. So I wanted to compliment you on
Well,
that.
thank
But
you.
it did just seem like a
Right.
long time, to
Mhm.
have lots of changes reflected. So thanks. I like your answer. Thank you very much.
Okay.
And I'll just throw in two thoughts. Number one, as I think everyone knows, we're in the process of doing a complete overhaul of our website. And one of the goals there is to have more interactive tools for educational resources. For example, like our new candidate toolkit that is online. And if you haven't seen it, I encourage you to look, and thanks to staff. Jacob in particular did a great job on that. And so those are the kind of things we're looking to move towards that can be updated on a more regular basis. Thank you.
Yeah, like the local candidate manual will be added to the toolkit, so it will be up to date. Yeah.
Okay. Any other? Is there any public comment on the manuals? Okay. Seeing none, do I have a motion?
I'll move approval of the manuals.
Commissioner Kasher,
Yes.
Commissioner Eskovitz,
Yes.
Commissioner Wasserman,
Yes.
Commissioner Nguyen,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, thank you, Linda. Okay, item 15 is in the matter of Frank Burgess. This, on December 19th, 2014, the Office of Administrative Law issued an ALJ's proposed decision in an enforcement proceeding against Mr. Burgess. The proposed decision was received by the Commission on December 22nd. The issue before the Commission is whether we should adopt the decision, adopt with modifications, or reject the decision. Both sides, Mr. Burgess and the Enforcement Division, have fully briefed the matter. We're here today to hear oral comments and arguments. Each side has been instructed that they have 10 minutes total. The Commission obviously can ask questions. After the presentation, we will go into closed session to deliberate. I'd like to just clarify there was a typographical error on the agenda, and that the closed section, which is correctly described for purposes of deliberation, should have cited to Government Code Section 11126 C3 and E1. However, it was correctly described as to the purpose of the closed session. So that will be noted for the record. And we're going to start with the Enforcement Division, and if you could state your name. And I don't have a good watch for timing.
I can
Okay,
give a
just give
2-minute
me,
break.
yeah, 2 minutes.
Angela Brereton for the Enforcement Division.
Good morning.
Good morning. If I may, I would like to reserve 2 minutes for rebuttal.
Okay, that John is going to give me a 2-minute warning.
Chair Remke and Commissioners, this case was heard and decided by ALJ Waxman. The issue before you today is whether to adopt the proposed decision with clarifying changes or to make changes to the proposed decision after reviewing the record. The proposed decision found that Mr. Burgess violated Section 87-100 of the Act and that he should pay the maximum penalty. As you know, Section 87-100 only applies to public officials, and the issue of whether Mr. Burgess was a public official was determined at the hearing. The evidence showed that the hospital was a public hospital, that it was owned by the taxpayers of the district. Even Mr. Burgess acknowledged that he was concerned with the taxpayers' money when he brought his packet of materials before the board. The hospital board members in 2010 filed Form 700s, and the entire district board, including Mr. Burgess, sat on the hospital board. The ALJ Waxman determined that the hospital board was a board of the district and that it was a local government agency and that Mr. Burgess was therefore a public official. Mr. Burgess argued that he was not a public official at the hearing, and ALJ Waxman took those arguments under consideration, and he still found that he was a public official. The Enforcement Division urges you to adopt the proposed decision with clarifying changes. The factual findings are consistent with the evidence that was presented at the hearing. The legal conclusions were all based on statutes, Section 87-100, 87103, and 83116. The statutes are the legal basis. Regulations help explain the statutes, but the statutes are the law. ALJ Waxman understood the law when he wrote the proposed decision, but he did make some simple mistakes. Regarding the element of economic interest, ALJ Waxman should have included the regulation describing business positions. However, his error was harmless. 18703.1 is the regulation, and it uses the exact language of the statute, which was 87103 subdivision D. That section states that a public official has an economic interest in any business entity in which the public official is a director, officer, partner, trustee, employee, or holds any position of management. There was no interpretation made by the commission when it enacted the regulation. The statute is both in the accusation and in the proposed decision. The evidence presented at the hearing proved that he held a business position as president and CEO in Burgess North American. ALJ Waxman applied the standard of the statute when he determined that Mr. Burgess had a business position. On page 9 at paragraph C, he states, as president and CEO of the corporation, respondent had an economic interest. Thus, because ALJ Waxman performed exactly the same analysis under the statute as he would have under the regulation, his failure to include the regulation is harmless. Regarding reasonably foreseeable, ALJ Waxman mistakenly included the 2014 version of the regulation regarding reasonably foreseeable. However, this statute, 87103, is the legal basis for the element of reasonably foreseeable. The regulation, both in 2010 and in 2014, include guidelines, helpful hints, not mandatory factors to be considered. Additionally, in 2010 and in 2014, reasonably foreseeable was determined to be more than a mere possibility, but less than a certainty. There is a presumption in the 2014 version that was not present in 2010. However, ALJ Waxman determined that the reasonably foreseeable element was met in spite of the presumption. On page 11 of the proposed decision, he states, even if respondent's economic interest in the decision was not explicitly involved in the decision, the financial effect of the decision on his economic interest would nonetheless have been reasonably foreseeable. Reasonably foreseeable is a fact-specific analysis. Using either the 2010 version or the 2014 version, because of the facts of this case, you reach the same conclusion. The facts here show that Burgess North American received more than $30,000 annually from its contract with the hospital board. It also showed that Burgess North American would lose that contract if the hospital board approved the new contract with DocuTrust. Even Mr. Burgess's conduct shows how foreseeable it was that the contract could be lost. He went to great lengths to get his information before the board. As stated in the proposed decision, on page 12, paragraph D, respondent stood to lose a lucrative contract with the hospital if the hospital board voted to change storage companies to DocuTrust. Knowing this, he prepared and distributed his packet to the other board members and then attempted to orally lobby them at the meeting before the vote. Respondent not only had an economic interest in the vote, the financial effect on that interest by the board's decision was more than reasonably foreseeable.
You're at the 2-minute point, and during that break for you, I do have a couple questions. Number one, I'm curious about the procedure that the Enforcement Division could have taken. Is there an option, or was there an option once the decision was issued, to go back and ask for a modification from the ALJ directly? Because you're pointing out that these are technical errors, and that would seem like a possibility. You don't have to answer now. I don't want to waste your time, but you can answer when you come back. And number two, just to make sure I understand your argument, it's that we have the authority to do this because these are technical, and even though it says those technical changes cannot affect the factual or legal basis. On the legal basis issue, you're saying we should be looking to and relying on the statute, which is what he was charged with, and not the regulations which support it or help interpret it.
That's correct.
Okay, I just want to make sure I got that right. Okay. Thank you.
She has 30 more seconds
30.
for the first 8 minutes.
You have a 2-minute warning, 6 minutes.
Yeah. Oh, sorry about that.
You have 30 more seconds if you want to use it or hold it. That's kind of a weird break in your thing. I'm sorry.
In addition to your 2 minutes, in addition to your 2 minutes for rebuttal. So
Okay.
you got a 2-minute warning for your 8 minutes.
How much time does she have left total?
Yeah, 4 minutes if we don't count the questions.
You've got 4 minutes.
I'll continue with my initial presentation if that's all right.
Please.
Getting back to reasonably foreseeable. So ALJ Waxman performed exactly the same analysis under the 2014 version of the regulation as he would have under the 2010 version. Therefore, the error was harmless. The proposed decision does need changes. The option that is available to you depends on how you characterize those changes. If you characterize the changes as technical and clarifying, then you should adopt the proposed decision and make those clarifying changes. If you determine that those changes are not technical and clarifying, then you should make those changes after reviewing the record. The APA does not require you to start from scratch. Doesn't require you to rewrite the entire proposed decision. You may pick and choose which issues to decide. If you choose, you can make changes to those legal citations regarding economic interest and reasonably foreseeable, and leave the rest of the proposed decision unchanged because you will have read the record.
Okay, and then so I guess with this extra time, and what about my question on the procedure that could have been? Was there an alternative?
Under the APA, there's no alternative for enforcement to contact the ALJ directly.
So there's no option for a motion for modification or correction.
Not in the statute, no. And I'm not aware of any procedure that allows the enforcement division to do that. The ALJ issues the proposed decision directly to the commission, not to the enforcement division. So we received it after it was already presented to you.
Well, it's presented to us just for filing and service. It's not as if it's now with us, because here you are still arguing as a party in the case. So as a party in the case, I guess I'm just asking, could you have gone back and made the motion to modify? And it sounds like you're saying, no, there's no such option.
Correct.
Now it's time.
Seems odd. Okay, so you have 2 minutes. Okay.
In this case, there's no new evidence that needs to be
Your 2
taken.
minutes
Yeah,
are
your 2 minutes are
over.
over. Sorry. Sorry about that.
Okay, wait.
If you want
Sorry.
your 2-minute rebuttal, you're done now.
Okay, may I have 30 more seconds?
You can use it all.
Okay. No new evidence needs to be taken in this case. All of the facts were established by the evidence at the hearing. The hearing established a violation of 87-100. Mr. Burgess was afforded every single constitutional protection, and he had his day in court. He presented evidence, and he was present. The evidence also supports issuing a maximum penalty in this case. Mr. Burgess does not want to accept responsibility for his actions, but the proposed decision found that Mr. Burgess made a choice, violated the law, and should pay the maximum penalty. The Enforcement Division encourages you to reach the same conclusion, either by adopting the proposed decision and making clarifying changes, or by making changes after reviewing the record. Thank you.
Thank you. Sir?
Have just a second to set up here.
Sure.
I have some exhibits. Where would you like me to put them so that you can see them? I could put them over here.
I guess let's clarify before you use the word exhibits.
The law.
Okay, it's just the law. It's nothing, no new
That's correct.
evidence that you're offering.
That's correct.
Okay, thank you.
So where would you like me to set it up? Over here in the
That
corner?
looks
Can
about
everybody see it
good.
here?
Sure.
Okay. All right. My name is John Pinkney, and I'm here representing Mr. Frank Burgess today. The alleged violation that Mr. Burgess is charged with is Government Code Section 87100. That's the primary violation that he's charged with, and that's what's at issue before you today. The burden of proof, and this is very important, the burden of proof is not on Mr. Burgess. Burden of proof is on the Enforcement Division and the FPPC. And I'll get back to that in a moment. So the other thing I want to point out is there are some salient facts in this case because it's a little bit confusing with the two boards. And just to clarify, there were two boards involved here. One was a hospital district, and Mr. Burgess was invited by members of that hospital district to serve on that district board, and he was appointed. He could have refused to serve on a separate body. There was a separate body, a nonprofit corporation, a public benefit corporation that is governed by the California Corporations Code, not the government code. If he wanted to, he could have served just on the district board and not on the nonprofit board. It's not required to by the district bylaws. But he did serve on both. And all of the events that relate to this case involve activities or events that occurred before and during the nonprofit board meeting. So I'm going to refer to that as the nonprofit. That's primarily what we're going to be talking
The
about.
hospital board is what you're referring to when you say the nonprofit board?
There are two boards.
I know there's the district board
district,
and the hospital board. Which,
And then there's the nonprofit board. It is a nonprofit. The hospital board is what it's referred to in the briefs, but it is a nonprofit. And so I'm going to refer to it as the nonprofit.
okay.
So we begin the analysis by looking at the law. And what the law says is the applicable law that he's being charged with violating, that they have the burden to prove each element of that law was violated. That's their burden today. And the law says, Government Code Section 87100, that no public official at any level of state or local government shall make, participate in making, or in any way attempt to use his official position to influence a governmental decision in which he knows or he has reason to know he has a financial interest. There's nothing in there about nonprofit corporations. Now, if we look at Regulation 18700, what it provides is a guideline, a 6-step process that we go through to determine whether there was whether the conflict of interest rules apply and whether they were violated. And it provides that to determine whether a given individual has a disqualifying conflict of interest under the Political Reform Act, proceed with the following analysis. Step 1, determine whether the individual is a public official within the meaning of the act. If the individual is not a public official, he or she does not have a conflict of interest within the meaning of the act. So what is a public official? They have to demonstrate that he was a public official. We go to Government Code Section 82048A for a definition of what a public official is. And it provides that a public official means, and I've highlighted I think the relevant terms for purposes of our analysis, a public official means every member of a local government agency. That's essentially what applies here. So what does that really mean? It's a little bit vague, and it says that a public official is a member of a local government agency. Well, if we look at Regulation 18701, it provides us with some guidance on what is meant by the term member. And it says, for purposes of Government Code Section 82048, the following definitions apply. Member, as used there, shall include, and I have copies of this for you if you'd like.
The codes, we have those. Thank
Okay.
you.
Shall include, but not be limited to, salaried or unsalaried members of committees, boards, or commissions with decision-making authority. A committee, board, or commission possesses decision-making authority whenever, 1, it may make a final government decision. There is no evidence in the record or in the proposed decision or in the briefs that have been submitted by counsel that they've met their burden on that item, that they've demonstrated that the nonprofit entity made any or had the ability to make any governmental decisions other than conclusory allegations. The second step is it may compel a government decision or it may prevent a government decision. There is no evidence in the record or in the proposed decision or in the voluminous brief submitted by counsel that the nonprofit board Mr. Burgess served on could compel or prevent a government decision. None. They have failed to meet their burden. Number three, it makes substantive recommendations that are and over an extended period of time have been regularly approved without significant amendment or modification by another public official or government agency. Again, there is nothing in the record, there is nothing in the proposed decision that satisfies their burden of proof on that issue. They have failed to meet their burden of proof. And if you look at the government code provisions that we're dealing with here, there is nothing in there that indicates that a nonprofit board or members serving on a nonprofit board are government officials, we're public officials. Doesn't apply. The express language, it does not apply, and they haven't met their burden of proof. Also,
Your client was a member of both of the boards simultaneously, right?
that is correct.
So your argument is that when he's serving on the nonprofit board, he's not wearing his public official hat?
That's correct. That's correct. Government code, so they have to demonstrate that he's a public official and that he was involved with making a governmental decision or trying to influence a governmental decision. Government code section 82041 provides that a local government agency means a county, a city, a district. None of those apply to the nonprofit, none of them. Of any kind, including school district, it's not a school district, or any other local or regional political subdivision. It's not a political subdivision. Or any department, division, bureau, office, board, commission, or other agency of the foregoing. Doesn't apply to a nonprofit. Now, they may contend it does, but they have the burden of proof.
Was it the, I call it the hospital board, you call it the nonprofit. Was that the board in which he was required to file the Form 700s?
I'm glad you asked that question. Mr. Burgess did file a Form 700
For which board?
for the hospital district. He was never asked to file one for the hospital, for the nonprofit board. He filed it for the hospital district. And it's interesting. So now let's look at what evidence we do have. We know what evidence is lacking, but what evidence do we have? The nonprofit board that he served on at the time he served had no conflict of interest code. The bylaws do not state that it is a government agency, that its board members are public officials. In fact, the bylaws at section 4.15 merely provide, quote, all members of the board of directors will complete a course in training and ethics similar to that required of publicly elected officials. If it's a government agency, if it views itself as such, if it's lawyers that drafted the bylaws view it as such, then they would have put in there that you have to comply with California ethics training mandates, not something similar. This is the kind of thing you see on a Chamber of Commerce bylaw, not in the bylaws of a public agency.
2-minute warning.
So is there,
I'm sorry, did you hear that? It's a 2-minute warning.
yeah, if I could
Yes.
indulge for a minute,
Sure.
this is important. In the decision-making process, is there record evidence about what happened after the nonprofit approved this contract? Did it then go to the other board
Well,
for approval?
it was not approved, but Mr. Burgess's, the company that his son owns, that he's president of, it was not awarded to him. He abstained from the vote, but
was
it
approved
was
at the
decided by
nonprofit.
the nonprofit. They run the hospital. I want to be real clear on this. This happens, and let me say, this happens all over the state of California. You have healthcare districts that lease out their hospitals to both nonprofits and for-profits. Some of those for-profits are traded on the New York Stock Exchange. I actually have a list with me, which I won't put into evidence, of all of the healthcare districts in the state of California that lease their hospitals to nonprofits and for-profits. I will tell you, they will be shocked to learn that the Enforcement Division contends that they are subject to the Political Reform Act.
But let's go, I think I have a follow-up to what Commissioner Eskovitz was talking about, I think, which was, so he sits on the district board. On the district board, he's known as a public official. He's required to file his Form 700. He's only on the hospital board because he's on the district board. So again, I think that's, how does he lose his public official status when he's serving in that capacity on that board?
Well, the only case that we have on point that's before you today is the Eden case. That's it. That's the only case that addresses
But
this
just
issue.
like more common sense, I'm even saying. So I'm a public official. I serve on this board. This board says all board members over here shall be part of our board.
Okay, but to be clear, what you're being asked to do is create new law.
I don't
no,
know.
to-
I'm saying
if-
I'm a public official, and I know that part of my duty is to sit on a hospital board.
You're being asked to create new law. You're being asked to forge and blaze a new trail here today, and now hold that nonprofits and for-profits. And if you look at the Eden case, in the Eden case, you had a hospital district that leased to a nonprofit. They shared board members, the two entities. The district was the community member of the nonprofit. Yet both the trial court and the appellate court level found that the nonprofit was not a government entity. That's the best case we were able to find. There's nothing that says that a nonprofit, or for-profit for that matter, becomes a public entity or a public agency when it leases and runs a hospital.
But
Not
I
one
think that-
authority.
I think you're assuming that a much broader conclusion. Again, I'm saying as a public official, I can be asked to sit on many boards. For example, the treasurer of the state sits on numerous boards. I don't change my status based on which board I go to. I'm still sitting on that board as a public official from the district board.
Well, there are multiple people that are on the nonprofit board that are not.
I understand,
On
but
the
we're not
hospital district board.
ruling on them right now.
Isn't your argument really about whether this is a government decision that he influenced? I mean, putting aside the question of public official or not, wearing one board hat or not, what is the evidence about the decision-making process in the record, about the decision-making process for the approval of this contract? Was it just approved at the nonprofit level? Was it presented to the other board as well?
The hospital was the one that was entering into the contract. The nonprofit was entering into the contract for document storage. That was the issue. It was
And
before the hospital nonprofit.
And it never needed to be approved at the higher level?
Not that I'm aware of. Not that I'm aware of. Certainly not in the record before you. But I think that's a good point. There are two issues here. One is whether he's a public official. We don't think they met their burden of proof. Second is whether it was a governmental action and a government agency. We don't think they've met their burden of proof. And I would say probably one of the most important issues before you today is an issue of due process. And as you know, it's well established that a law which requires those subject to it to guess as to its meaning inherently violates due process. We're all lawyers here. We're sworn to uphold the Constitution of the United States. More important in this case is due process, because it's essential to a free society. And when you read these rules, they don't say that they apply to a nonprofit.
Let me, Commissioner Wasserman, did you still have a question?
Yes, actually.
Go ahead.
So Eden Township occurs in the context of Government Code 1090,
That's correct.
conflict of interest. How do you reconcile that or distinguish it from how we've interpreted our regs in re Siegel with respect to when as you say, a nonprofit or a corporation is falling under the government code, specifically this violation question before us? Because I thought this is something that we've already released guidance on. Well, I mean, because I understand you have this concern, a constitutional concern, but I thought we had already presented the interpretation of how that occurs.
You're talking about this body.
Yes, this body.
Okay. Well, the
Which
case,
I don't think it's been.
I'm sorry,
I don't think there's any case law that is
directly on point.
has interpreted that any different than the way we've interpreted it.
Well, I would concede the fact that I don't think there is any case that we've been able to find, published decision from a court that is directly on point. We've given you the best case that we could find that states that deals with this issue. They've presented nothing. contrary to that. And they have the burden of proof, not us. So I need to close.
Yeah, you do.
Okay, so in closing, I would like to say this. This case and what you do in this case, it matters. It matters because in a free society, we have to tell people what the rules are that we're going to hold them accountable for. The law does not say that it applies to nonprofits. A nonprofit corporation governed by the California Corporations Code and all of the activities related to actions taken at a nonprofit board meeting. It matters to all of us in this room as lawyers because we've sworn to uphold the Constitution. And more important than this case is due process. It's far more important than this single case. And perhaps most important, this case is today in this room to Mr. Burgess, because he's 80 years old. He's had a stellar life of public service without any blemish, without any charges ever against him. 12 years on the city council, served on different chambers of commerce and on this hospital board. No prior issues, no dispute that he was totally candid, upfront, was told by the secretary of the board that he could pass this out. That came up during the trial. And yet they're going to throw the most egregious penalty at him. So I ask you, he's here today fighting for his reputation, and let him walk out of here with his reputation. We ask that you reject the decision, and that one of your options is reject the proposed decision and decide the case upon the record. We agree with counsel. You don't need any further evidence in this case. We're withdrawing any request for further evidence.
Thank you, sir. Okay, you officially have a minute, but I believe we just went over by at least 2 minutes, so be a little generous on that. And while you're walking towards there, I'm just going to ask you 2 quick questions, I hope, to make sure I'm understanding the facts correctly. That he was a public official from being on the district board, but he was on the hospital board as that same public official from the district board. Is that correct? Is that a fair assessment or no?
I believe that's true, but I also believe that the members of the hospital board were public officials in their own right, based on the evidence that we presented at the hearing.
But do we have to resolve that issue, the bigger issue? Does the whole hospital board become subject to this if we're looking at one individual here? I'm just asking, is that the position?
I don't think we need to. No, I believe that the ALJ Waxman got that right in his proposed decision when he said Mr. Burgess was a public official in this matter when he was acting as a member of the hospital board. I don't think we need to go any further than that.
Yes.
So just as a follow-up question, if I was sitting on that hospital board as a member of, some community organization, not as a member of another governmental agency, would I be filing a Form 700?
Yes, the testimony that was presented at the hearing showed that all members of the hospital board filed Form 700s, even in 2010.
In 2010, that wasn't an issue about the subsequent passage of that requirement?
That's correct. It had always been that for the hospital board members to file Form 700s. It was not specifically mentioned in their bylaws before then. But the chair testified that they filed Form 700s. They were public officials.
Okay, if you want to wrap up, you have a couple minutes.
Mr. Burgess is trying to confuse the issue that's before you, but really the only issue that is here before you today is how you characterize the changes that need to be made to the proposed decision. ALJ Waxman got everything right. He got all of the steps right, whether he was a public official, whether there was a governmental decision, whether there was material financial effect. The only ones he missed were economic interest and reasonably foreseeable. And those are...
Sorry, let me just go back on the governmental decision issue. What was the evidence on the record? It's basically, the argument is that every decision made by the nonprofit is a government decision.
That's correct.
And what's the evidence?
The evidence was that it's a public hospital, that it's owned by the taxpayers, that the public hospital is governed by two boards, the district board and the hospital board. The decision then before the agency was a governmental decision because it was a public hospital.
Why is it governed by two boards?
I honestly don't understand exactly why it's governed by two boards. It was set up that way, as I understand, when the political subdivision was created for the district. For some reason, they determined that it needed to have different governance for the district itself for owning the property, and then for operation of the hospital, they wanted a different governing board.
And just staying within the record, is there evidence about whether the approval by the nonprofit board was later approved at the district board level?
There is no evidence of that. So the only two elements that ALJ Waxman made a mistake on were the economic interest and reasonably foreseeable. Both of those elements are in the statutes. So by making changes, you're not changing the underlying law. The evidence also, I should touch on briefly the
I
nonprofit
think
issue.
at this point, you're going to need to wrap up.
Okay.
We're way over time. Thank you.
So the evidence does support the maximum penalty in this case. Mr. Burgess was an experienced public official. He should have known better. He should have known that his economic interest that he reported time and again on his Form 700 that would cause him a problem if a contract with the hospital came before the board. At the very least, he should have known to ask. This was deliberate conduct. He did not accidentally place this packet before the board members. He very clearly made a choice and placed it before them. ALJ Waxman considered all of the mitigating factors that Mr. Burgess just mentioned, and he still decided that it was appropriate for the maximum penalty. That's all I have. Thank you.
Thank you.
Thank you.
Okay, at this point, we'll go off the record and go into closed session. And again, that's for deliberation purposes as noted on the agenda. Thank you.
Oh, but if you guys needed, yeah. And then you guys would be once they would start looking at. Okay.
Sure, it was on.
call roll again for Sure. Would you like roll call again for return?
Okay, let's get started. Call roll again, please.
Commissioner Kasher,
Present.
Commissioner Eskovitz,
Present.
Commissioner Wasserman,
Present.
Commissioner Nguyen,
Yes.
and Chair Umke.
Yes. Okay, following closed session in our deliberation, the commission rejects the proposed decision and will decide the case upon the record, including the transcript. The commission would like the parties to further address, without limitation, the governmental decision element under Government Code 87100. A copy of the record shall be made available to the parties. The commission is going to proceed on this matter on written argument alone, and I will issue an order as to the briefing schedule today.
May I speak just briefly? We'd like to request oral argument if there's going to be.
Well, why don't you go ahead and wait for my order, and then you can make a formal motion.
Sorry.
Okay. So moving on, we have the executive staff reports, item 17, and we're going to start with the legislative report, but I believe that Ms. Peth had a something you wanted to start with. Is that correct?
Yes, thank you, Chair. We just, so as we had noticed on the agenda, we were, as a staff, recommending that the commission take action to support Assembly Bill 594. But since this meeting was noticed, which was 10 days ago, we've been in discussions with the author's office, and he's considering additional amendments to the bill. And so we're pulling our request for the commission to take action today, so that we have additional time to work with the author's office, and we'll bring back the bill once it's in a more final form to the commission for consideration and deliberation.
Okay, thank you on that. Does anyone have any questions on that or any other issue on the legislative report? Okay, seeing none. And any questions on any of the other executive staff reports? Okay, thank you. Those will be submitted. Do we have any other issues? Okay, I move to adjourn.
Commissioner Kasher,
Yes.
Commissioner Eskovitz, Commissioner Wasserman,
Yes.
Commissioner Nguyen,
Yes.
Chair Umke.
Yes. All right, thank you.